Hello everyone, I am Anuj Nakade and welcome to LiveLaw. The news we bring today is from the Madras High Court about an unfortunate incident of discrimination in the Madras Bar Association. The incident in question occurred in 2012. It was alleged by one Mr. R. Neil Roshan, a practicing advocate at the Madras High Court, that he was sick and feeling weak and he wanted water. He narrated in his affidavit that then he rushed to the water filter kept in the Madras Bar Association Hall in the Madras High Court. It is worth noting that as a young advocate, he was not a member of the Madras Bar Association at this time. It is alleged that when he was filling water in his tumbler, Senior Advocate P.H. Pandian, a member of the association, forcefully snatched the tumbler from his hand and shouted, quote, "You do not drink water here, go out." On the same day, Senior Advocate Elephant G. Rajendran, the father of Advocate R. Neil Roshan, filed a complaint about this incident. Soon after, in the same year, Senior Advocate E. G. Rajendran also filed a writ petition in the Madras High Court highlighting a culture of exclusivity and elitism in the operation of the Madras Bar Association. The submissions in the petition even say that during the last 10 years, the syndicate senior advocates of the Madras Bar Association admitted as members of the MBA only the advocates who are relatives and juniors of other senior advocates. He contended that since the association was functioning upon public money, the facilities provided could not be denied to other practicing lawyers. He added that the actions of the association were discriminatory and deprived lawyers from utilizing public facilities. Among other things, Senior Advocate Rajendran also contended that the association did not follow a transparent and democratic norm or guideline while admitting members. He also added that the action of the association, hosting meetings, parties, etc. within the high security zone of the Madras High Court, posed a threat to the High Court. He also brought to the attention of the court various instances of discrimination where the association had, in a discriminatory manner, not considered the membership application of different persons. Hence, the petition sought directions to be issued to the MBA to file a detailed report from 2012, highlighting first, how many applications are pending for membership, and second, how many are the juniors or sons and daughters of senior advocates who are accepted as members of the MBA. It is unfortunate that Advocate R. Neil Roshan has since died in a road accident and Senior Advocate P.H. Pandian is also no more. In its response, the Madras Bar Association denied all such allegations and submitted that the incident of denying water was incorrect. It was also submitted that the association had since then fitted 2 water cans for the usage of practicing lawyers. It was also submitted that the matter may be closed since both the senior advocate and the petitioner's son, who were the 2 individuals involved in this incident, were no more. A single judge bench of Justice S.M. Subramaniam heard this matter. The court noted that social issues did not die with the persons and it was necessary to address the social issues in the interest of the future of the country. The court added that such issues could not be left casually as they would affect future lawyers who are necessary for the development of the justice delivery system. Observing that the practicing lawyers cannot be deprived of access to drinking water merely on the ground of lack of membership of the MBA, the court added that the present case was regretful and that both the bar and the bench should avoid such trivial and unwarranted situations. The court also considered a broad reading of Article 17 of the Constitution, which abolishes untouchability, saying that it is not merely caste-based discrimination but also included all forms of social exclusion which have their basis in ideas of purity and pollution or hierarchy and subordination. The order of the court reads, and I quote, "A broad reading of Article 17 means that not only the caste-based practice of untouchability falls within the ambit of the constitutional prohibition, but practices that bear a family resemblance to untouchability are captured as well. This requires the court to ask whether a particular practice like untouchability is a practice of social subordination, exclusion and segregation based upon an idea that certain personal characteristics, whether caste or gender or menstruation, can justify relegating individuals to an inferior position in society." The court elaborated on the concept and noted that it was class discrimination. The court also held that even class discrimination would come within the facet of untouchability when it is based on economic status. The court said, and I quote, "Now the writ petitioner, though raised the ground of practicing untouchability in Madras Bar Association, the said allegation cannot be considered in the perspective of caste discrimination. It is to be construed in the perspective of class discrimination, which is also to be construed as untouchability if it is practiced on the ground of economic status, dignitaries, or non-availability of proposer or second proposer as per bylaws of the Madras Bar Association." The court also made a note of the restrictive conditions of membership of the Madras Bar Association and asked the MBA if the intention is to create an elite society of lawyers. If so, then the same cannot be done at the cost of public money. Referring to the provisions of the Advocates Act and the BCI rules, the court said that the choice of membership of an association is not of the association, but of the individual advocate. The court also made a note of the allegation that sons and daughters of dignitaries are admitted as members of MBA under extraneous considerations. The court noted that the lawyers being a homogeneous clause, further creating divisions on any criteria including economic status or otherwise will result in losing faith, and ordinary lawyers will get frustrated, and there is a possibility that young and talented lawyers will leave the profession. It is the duty of the judicial institutions to provide an atmosphere that is conducive to everyone. So, the court has directed the Bar Association to pay a sum of 5 lakh rupees towards compensation to the petitioner for the untoward incident. The court also directed the association to admit the advocates whose application for membership had been pending for a very long time. It also directed the association to distribute membership applications to all interested lawyers practicing in the High Court and admit them without any discrimination on the basis of caste, gender, religion, economic status, personal affiliations with senior advocates or dignitaries, and political affiliations without reference to the draconian bylaws regarding eligibility criteria to become the member of Madras Bar Association or amending bylaws suitably. In the event of failure on the part of the association, the Madras High Court Administration and the Bar Council of Tamil Nadu are bound to initiate all appropriate actions in the manner known to law. The Bar Association's functioning in the High Court premises were also directed to obtain prior permission from the Registrar General of the Madras High Court for holding celebrations, functions, birthday parties, lunch parties, etc. in the interest of safety and security in the High Court premises. That's all we have for you in this video. If you would like to find out more about the case or read the order of the Madras High Court, please visit our website at www.livelaw.in. We will also leave a link to the full report in the description. If you found the video informative, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.